Many people ask the question, is it possible to prevent families arguing over an estate or just fighting amongst themselves? The short answer is no. It's very, very difficult nowadays to deal with the issues of fighting within families, because the sad fact is many more estates and many more wills are challenged by siblings and family members. And one of the key questions that I ask nowadays that I never asked years ago of people making wills is there anybody going to fight over this will? Is there anybody who has an expectation that they will inherit from your estate? And people often look at me strangely, but the sad fact is people fight. If I think there's going to be an issue of siblings fighting or people fighting with the surviving parent, I often suggest that people don't appoint a single family member as one of the executors of the estate. Simply because it's a lot easier to be very clear with family members and beneficiaries how the process works, what's going to happen and what the consequences are if they argue amongst themselves. And mostly that's about cost. For every argument a solicitor has to deal with, it usually costs the beneficiaries in terms of a bill or, reducing the value of the estate. And for us it's amazing how quickly people will resolve some of the issues. I do know some solicitors who will lay the law down very strongly and say, if you fight, my fee goes up by a certain percentage. Many questions arise at the early stages of administering an estate, and one of them is, I can't find a will, what do I need to do? Believe it or not everybody in the country makes a will. I think roughly about 70% of people don't have wills. So not finding a will wouldn't necessarily be unusual. But there are set procedures you can do to identify whether a will exists or not. Traditionally, solicitors who are dealing with an estate would ring round all the other solicitors or write to all the other solicitors asking if they had ever had a copy of the will or whether a will was made with them. And if that doesn't bear any fruit, then there is the option of the National Wills Register, and you can log on and check out if there are any details of a registered will in that person's name. But it's not unusual. Sometimes when people make wills, they don't do anything with them for another 20 years, and it often happens that some of the beneficiaries named in the will have already died. When we make wills with people at the Law House, we ask them, particularly if they've left a specific gift to somebody, what would happen if that person has already died when you have died? Do you want to make provision for somebody else to receive that asset? Sometimes they do, sometimes they don't. If they don't, then that asset just simply forms part of the rest of the estate. Normally, we will ask people, particularly if we're making a gift to a son or a daughter, if they died, would they want that asset then to pass to the grandchildren? And it's very common practice for that to happen. Sometimes we're asked to deal with an estate where the executors have died, and that's again not unusual. People make wills, live a very long time, and the executors that they've named, alas, have died before them. Normally, the beneficiaries named in the will can apply to become what is in effect the role of an executor in the administration of the estate. Sometimes when we're dealing with an estate, there just isn't enough money. Many people die with a lot of assets, particularly a house. Most people's biggest asset is their house, but they don't have a lot of cash in the bank. And it's often possible, usually with the aid of a solicitor, and we at the Law House certainly do this, is arrange for a loan to be taken out against the asset in order to settle such things as inheritance tax, arrange the funeral, and ultimately pay for the funeral. We generally find that funeral directors are quite accommodating within reason, and often you do need to pay tax against a property in order to get the grant of probate, so we tackle it from two ways. Time limits in terms of dealing with an estate vary. Sometimes they can take between 2 and, believe it or not, 10 years. This depends on a lot of things, how well the beneficiaries get on, whether there are any arguments, whether there are complex tax issues such as overseas property or overseas bank accounts. Some countries are faster at dealing with assets in the UK than others. There is one specific time limit for dealing with an estate. If there is any inheritance tax due on the estate, then it needs to be paid for at the end of the first 6 months from the end of the month of the date of death. At the law house, this can become a problem, particularly when people have attempted to deal with the estate themselves and often have exceeded that period. So we end up doing a lot of negotiation with the tax office.